Good morning, everybody, and welcome back to Courtroom Confidential, the fastest growing true crime channel on YouTube. Go ahead and fact check me if you think I'm wrong. Thank you, everybody, for taking the time to join us on a Sunday morning. I know it's a little bit early for those of you on the West Coast. On the East Coast, it might be just perfect. But we were trying to find a time that we could get as many people to join us to do something what we think is a little bit fun. So I see a lot of familiar names, Donna and Afton and BGOG, some very familiar names in the chat. Margaret, hello, good morning to everybody. Thank you so much for taking the time to be here. This is the plan, very straightforward. We are going to go into the opening statements for Sarah Boone. Now, I have not watched them. I have heard about them. I have not had the time to really go through it. And I thought, well, why take the time by myself? Why not do it with all of you fine folks? And we can react to it together. My understanding is that they are not super long. My understanding is also that they're not super impressive. So we'll see if that holds true. And I've been told that hi, Judy from all the way from South Africa. Wow, I like this. Everybody checking in. Judy from South Africa. And then we got Pat from Mexico. Thank you guys for taking the time. I also understand that they are, the sound is awful. And hello, Kirsten from Sweden. So there's nothing we can do about it because the sound is awful on their end. We tried to find the best feed that we could as far as the sound goes, but the problem is that both of these gentlemen, the prosecutor and the defense attorney, walk away from the microphone. So their sound will drop off dramatically. It's hard to hear them. Then they go back to the microphone and then you can hear them. Hello, Mary from Australia. Oh, wow. Lindsay from Zimbabwe. Hello, Lindsay. And then we, good old Oklahoma in the house. What do we got? Olympic Peninsula, Washington. So we're covering the whole map. So here's what I suggest. I'm actually wearing ear pods, which I normally don't do, to hear this. It's probably going to be a problem where you're going to turn it all the way up to try to hear what's being said, and then it might blast your ears. I'm just going to warn you. I'll try to be cognizant of that. But it also might be a problem where if they're speaking really softly and then I want to jump in to give you some real juicy hot take on what just took place, my volume might be a little bit too much for you. So I apologize ahead of time. I've seen the complaints on other channels that people are like, the sound is awful. I don't think it's a quality problem. I think it's a volume problem. Anyways, that is the long buildup. Let's go ahead and just jump right into this thing. I will try to jump in here or there if I feel that there are things worth mentioning. Then we'll chat, maybe answer some questions at the end, and then we have a couple of announcements at the end for you guys that I think you will enjoy. All right, let's jump right into this thing. If you guys could hear that, can you guys hear anything? No sound. Okay. What do we do about this? We don't have any sound whatsoever. You know what? Maybe it's a problem with my AirPods. I'll take my AirPods out and we'll start it over. I apologize, you guys. Let's see. I've got the volume turned all the way up on my end. Nothing's happening now, so if you should be just hearing a buzz, if anything.
I thank you both for your honesty. I appreciate that. It's something we talked about earlier this week. That's the one thing that we were required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty.
Can you guys hear that?
In the elevator, was there anything that you saw or observed that would impact you or influenced you in any way to have any impact on you?
Okay. Thank you. Sorry about that.
First row.
All right.
Juror number 4, left to right, first row.
At least we didn't get half an hour in before I noticed.
We're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. At the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir. Thank you.
Ladies and gentlemen, what the evidence in this case is going to show you that this defendant, this Jorge Torres, shot in a suitcase. He was able to do this because at the time of his death, he only weighed 103 pounds. She did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know.
All right. I hope you guys were able to hear that. It is a little soft. He's standing in front of the jury while he does this, and I don't blame him for that. I mean, he shouldn't be preoccupied with, where the microphone is just so people online can hear. So I'm fine with that. He did a couple of good things here. He approached the jury. He got right into the theme of his case. He didn't waste a bunch of time talking about, introducing who he is, who the parties are. I'm going to tell you a story. This is a roadmap, blah, 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 blah. I like it. He went right in. He said, this woman zipped this guy up in a suitcase. She was able to do that because he was 103 pounds at the time. She had the malicious intent to punish him. So already we're getting the theory of intent here that they're going to be used. And then she said she went upstairs for him to take his last breaths alone. All very good. Sets a theme, gives some emotion to it. The idea that he took his last breaths alone. Love all of that. He himself looks like he's a little bit uncomfortable. But you know what? He's standing right there in front of the jury. He's not choking over his words. So I hope you guys are able to hear all of that. I will let it play and try to not disturb you too much.
Of this event. Evidence is going to show Jorge Torres is dead because in this defendant's judgment, sir, you have a conscience to regard for whether he lived or died. You will see, hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, for everything you've done to me. Sarah, fuck you.
And then the defendant laughs. Sarah, fuck you. And the defendant laughs. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't fucking breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah.
Okay, Sheila makes a great point, and I was completely agreeing with this. I'm not quite sure if he was given an instruction that he's not allowed to play the video during the opening, or if there's an audio visual element in that courtroom that prevents him from doing so, but I couldn't agree more. That is the most powerful evidence you have in this case. Absolutely send a knockout punch in the opening statements and play that video. It is still troubling to hear the words, but come on, there is absolutely nothing replacing that video when you're staring at this man in a suitcase begging for his life, knowing that she's holding the camera and hearing the weight. I mean, you know, he says she laughs. There's no way to replace the inflection in her voice. Again, I don't know if that was a choice that he was limited to, but if that was a strategic choice, I do think he missed an opportunity here.
You could probably shut the fuck up. Sarah. Shh. Is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah.
Fairly obvious what is probably in that box behind him. Am I right?
How did we get to this point where 103-pound Jorge Torres in this suitcase? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time, several hours. And she goes downstairs. See Jorge Torres. And eventually realizes, the first thing she does, take him out. I think if you were here, the description is like, little like out. And try to protect the patient. Here's her thing that she tries to down on these 103-pound chest, puts and whatever hair was trapped in there. And the next thing she does is she didn't call 911. Call Brian. Brian, her ex-husband. They share a child in common. And this day, February 24th, 2020, is on Monday. Normal work day for most people. School day
their child to share common. But after they got divorced, the arrangement was after no co-parents. And that weekend we provided that Sunday. Reasonable. And Monday through Tuesday, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Newton's responsibility. So February 23rd, 2020 was a Sunday. Now he's led into Monday.
All right, he's losing a little bit of steam here. And then I saw somebody commented, thank you so much, that this was actually part of the pre-trial or pre-opening statement motions, that they're not going to be playing any video. So it might not have been a choice of his. But he does seem to have lost something of momentum and value not having played that. Fine, you know, you got to pivot, you got to deal with how that's part of doing trials, is being able to shoot from the hip and pivot. So good on him that he just found a way to get that evidence in there anyways. But now it does seem that he's reaching a lull. I mean, he's just not the most dynamic speaker in the entire world. By the way, nothing against this guy whatsoever. This is 98% of prosecutors and defense attorneys out there. We are all spoiled by the Alan Jacksons of the world who happen to make it on TV, but the vast majority of people doing trials are people just like this gentleman. Very apt, very competent, but just kind of straightforward and nothing, no real presentation or charisma behind the entire thing. I'm going to let this play again, but one last thing that I noticed is that new crowd of spectators behind the judge there is kind of funny to me, that it sounds like he let his courtroom law clerks and research attorneys come out, but didn't actually give them a seat in the audience. So they're just sitting behind him like his bodyguards there, which is kind of funny to me. If you guys have questions, please put them in. I'm going to try to save them and highlight them and try to get to as many of them as I can at the end of this.
She was going to get their child after school. And there had been a history of reliability. So you will see in the phone record, and she finally called him back. Being the nice co-parent that he is, he comes over. Sure. And then she's explaining to him what the heck is going on. He's in through the front door of her townhouse. We allow you to view all the way to the back behind the glass door. You're going to see their kitchen, it's off to the right. There's a doorway that you can see all the way through. And on the back side of the kitchen and the breakfast room area, tables and stuff. There's also some blue lights sticking out in view. Brian Boone says, check, please. You need to call 911. He doesn't look at that. He doesn't wait outside. So now, after 9/1, call her ex-husband. After 9/1, waited for Brian Boone to come over. The defendant makes the 911.
What you will not hear are tears. What you will not hear is sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in the suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And
Take the glasses off of your head, dude. I'm sorry, but this is, come on. First of all, hello, Gazella in the chat. So nice of you to join us. I'll give you guys a little sneak preview. We're going to be having Gazella and the Grizzly True Crime contingent as a guest on our new series of interviews that we're going to be doing on this channel. So thank you so much for stopping by. Always great to have your support. Again, it's unfortunate that he was unable to actually play the audio from the 911. You know, that reading, again, he's doing the best he can. It's just this is such a dramatic case. It's one of those really once in a career type cases for this gentleman, where you have a case with this much, first of all, nationwide attention, but then also this much intrigue and drama when it comes to that videotape and the statements that she made to 911 and to officers afterwards. And, you know, the opening statements don't make or break a case, but they certainly set the theme. And it's unfortunate that he was not able to play some of this actual audio and visual. I would have loved to have seen that. And obviously, if I were in his position, I'd be frustrated too if he was actually told that he could not do that. But he's doing the best that he can. But at this point, he is just kind of getting into storytelling, and he's lost kind of that original impact. We'll see if he can't bring it back around.
From positional asphyxiation, meaning like you're not going to get full breath when you're probably above like and environmental suffocation. You don't have to have a plastic bag over your head, a shot with full roll of duct tape to seal it off 100%, be worthy of back into space to environmentally suffocate. It's close enough. You can't get oxygen, CO2 coming in and out. But you also did notice, one porch trauma, torso, space. Really work treatment will help her explain the bruises. Should use words like hematomas will help her understand for you all that means bleeding under the skin and blood, like the bruises, whatever. But it had all this additional trauma, and trauma on its fingers as well. So now, sheriff's office, Orange County Fire Rescue show up. And the defendant interacts with the first patrol officer. See and hear that body on camera. It's more of the same as what we heard from the phone call. I see. It was good. I fell asleep. What happened? A few hours later, the detectives from the homicide unit of Orange County Sheriff's Office approach her, are ready to interview her after doing some initial things, includes her cell phone, on the computer that was found at the suitcase giving it to one of the digital privacy cameras, earphone, later in the trial. But it's time to give the first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But
The basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are $7.50 of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, we begin to do the math. And there's receipts. The day before, Saturday, February.
Not a small point. I wish he had needled her a little bit more with that, but you know, potato, bottle of wine. We're talking about a magnum compared to a regular bottle of wine. Maybe gives you a little more understanding of the level of intoxication taking place in that house there. Again, take the glasses off your head, dude.
22nd, 2020. There is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday,
it's quite a bargain.
PM, there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished with what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class.
Smooth.
Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, and her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. So they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around with the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out. We're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drank, smoked, did art, listened to music, played with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police.
That's an interesting insight. If you think about it, you know, they're obviously dealing with substance abuse, you know, alcoholism, most likely. You've got people who are buying, you know, $9 bottles of Magnum sized wine. I'm not a wine aficionado, but that sounds like they're buying the cheapest wine for the most at the cheapest they can possibly get. She says they had to switch from liquor to wine because of their budget. So they're living, you know, they're brushing up against poverty level if they're not already there, and spending what money they have, it sounds like, on wine to get themselves completely intoxicated so they can play childish games like, you know, quote unquote, play games like hide and go seek. But I mean, I make the point to say that he's at least painting some texture on the scene of who this was, what these people were, how they were living, how it could have led to this point. I just wish you would kind of get there a little bit more quickly, because he's starting to lose me, and if he's losing me, I wonder how those jurors are holding up.
What they are doing, by they I mean more sheriff's office department. That's when they discovered the two videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with them, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped them over. I flipped them over, and that's where it was. God, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase.
Okay. So this is starting to annoy me a little bit here. He's I mean, one thing I'll give him credit for is that most of this opening statement is extemporaneous. He doesn't, he's approaching jury speaking just from memory. But he's getting bogged down here with, he's trying to do, it seems to me, like a Cliff Notes version of her statements and interviews, because he's not playing it. But this looks to me like he's picking out quotes on the fly. And this is boring to watch. This is boring to listen to. It's not really scoring much with the jury. Why not just tell them, hey, you're going to hear, her statement. Her statement is going to tell you, and then just kind of summarize it in your own words. But this isn't getting me anything. And it's starting to really start to bog down.
Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happened before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it, because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my dog.
She's just thinking, I could really go for a snack right now.
Told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo, sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of. And that's the case. But we, in Florida, and members of the jury, and our attorneys, are all going to come up to the door that says, danger, keep out, stay away, court order. That court said, then is the door, we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire words. Vampires
Why? Participate in this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years. And as we come inside this room, after that meeting, we're going to have things pointed out. She would like us to open. And you're going to hear the first night the defendant met the decedent, Mr. Torres. He smacked her phone, punched her. The first time in her life she ever been punched. He made her curl up and feel position on her own porch for 4 hours. She was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score. His blood alcohol level was a 3.2 months. He got treated. This is a man who had a serious problem. You're going to hear about it. Despite that first date, and this is going to tie into some other things that I think about. Despite that first date, despite at that point in time of this first date, not having a relationship, emotional ties, the things that come along with a relationship that make it harder to break off a relationship. It's one thing to have a bad first date. It's another thing that you miss one time in your marriage. Despite that first date, there's a second and a third. Now these days are, but and it just typically ends up nothing I suspect. You're going to hear this, she said. It's one thing or the other. Like I asked the dude for a cigarette, before it flips out, and I'm going to pay the price. Just things like that. You're going to hear, potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing. But us in the face, asking the person about it, it's mentioned in the interview. What do you hear? That wound in the leg. Which is perhaps described as storytelling playing around.
All right. It's funny. He said, and that's the case. And then now he's been kind of carrying on for the last 5 minutes with these afterthoughts. I thought at first these were prepared comments that he was just doing extemporaneously. Now that just seems a little bit stream of consciousness to me, which is unfortunate too, because, he does have an incredibly dramatic case to work with. I've said it before, but it's rare that you have an opportunity with such incredible emotional intrigue. And he's squandering that to a bit with this kind of it does not seem like prepared comments to me. It seems like just kind of stream of consciousness comments. When I said extemporaneous, I meant, it's one thing if you have all your thoughts prepared in your head and you just speak from memory. It's another thing if you're just kind of shooting from the hip, which appears to be much more of what's happening here. And, like in anything that you do, especially an opening statements, closing argument, there should be some story arc to it and some momentum. And you want to end on this big note. And instead, he seems to be just kind of throwing last minute thoughts in front of these people. And again, I see a lot of people talking about this in the comments too. Yeah, you're right. This isn't the evidence. This is just kind of give them an idea of what took place. So they don't need to hear everything, but he seems to want to kind of present everything to them. I don't know, slightly disappointing. I don't begrudge this guy. He's very, very competent, knows his case, but this was a little lackluster. I can see now why people have reacted the way they have.
labeled the defendant and the victim's advocate. I'm not going to go into that now. This all comes to fruit. The blooms on the tree or trial, we'll discuss it again with one role. But that's not rough judgments, just hear all of the evidence in the case. Then apply whether or not these evidence has anything to do with what happened. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear.
Also, this analogy he's using, I'm not following it. I feel like the jurors are probably lost. If you're going to use some sort of algorithm, metaphor, what have you, at least make it, strikingly clear the point that you're trying to make. The last thing you want is your metaphor to be far more confusing and people are wondering about what you're talking about and losing the point.
There's some things that we would hope that we pay attention to during all testimony, if there is any, about the circumstance. One is that not actually a recognized diagnosis, the Bible they use mental health called PTSD and diagnostics, annual version 5.
Oh boy.
What it is, and what they describe it as, is kind of a component of post-traumatic stress. But because it's not actually in the book, it's like a recipe book. It's like our status books for lawyers. You go into this book and put this order of diagnosis. Okay, well, all these three elements are elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You have this book. You can rent it for that. But because there's no, it's not in the book. Some disagreement about the experts. It's kind of like grandma's recipe and down from generation to generation. But what I expect to hear is, it's important for people who don't have experience in certain of these relationships that are violent to understand the control that can be exerted over an apartment, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well. Perpetrated on her, you'll hear about it. And what it ties into at the end of the day, after we talk about this during the reflection, is if there is the self-defense structure, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better in society. Years ago, when this was first being observed, the question would be, well, why don't you leave? And that stuff in the testimony of the experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why. Well, now, returning to the fact of our case, what you're going to decide is ordinary, objective, reasonable person in those circumstances taking an action if you get a self-defense requirement. That's what it's used for. It's not used for explaining the subjective.
This just got bad. I'm sorry, but it seems like the court clerk is sending SOS signals with the blinds there in the background, and I don't blame her, because this has got bad. This to me has stepped into the realm of now unprepared and just kind of him free form philosophizing to these people. None of this is helpful. All of this is kind of confusing to them at this point. I hate to be so critical of these people, because it's easy to sit here in my chair and criticize, but he's really not. I mean, he's losing them. I feel he started out with a bang in comparison, and now I feel like he's got to the point where he's telling them things that they may or may not hear, telling them how it may or may not apply, getting into the philosophy behind battered spouse and why that might work, and they may get an instruction or they may not. It's like, come on, you had it going, you made some good points, you let them know what they're going to hear, and you get in and you get out. You don't need to use up every minute of your time just because you were given that time.
Just like any expert, a home inspector. If a home inspector report is based solely on the person trying to sell a house.
Now we're on to home inspectors. I mean, it's
Brand new JVC pipes. This sucker's good to go. You're not going to take that home inspector report, let's say, lift the hood, take the tires, do all the things with the box. You want an expert to get reliable information. Information he or she wants. They would say, you gotta take into account credibility of the person who's giving the story, even if it's the patient, the client that is saying all these things happen in the world. You gotta find proper information, not check the reliability. Particularly, circumstances that we've got. Not opinion that there's only 5 million. Just because there's a bunch of nonsense going on between two different partners doesn't mean that responsibility applies. Some people can go home and fight like cats and dogs. That's just their day. They get over it. They live their life, find another thing. Their cycle will just spin with them. So just because you hear about these things with the experts, doesn't mean that it necessarily applies. If this is testimony from I expected, Dr. But we'll talk to her about what she relied upon to make that conclusion. We'll talk about some of the things that we make that term together. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, you don't have to rely on the credibility of anything other than statement in return of the work. The evidence is going to show that the defendant killed Mr. Torres, which she decided to not because the evidence will show an objective, reasonable person for services. Thank you, Mr. J.
all right. Well, yeah, I'm sad to say that I was not impressed by that. This guy's been somebody made the comment, and it's an excellent point. He's been living with it for 5 years, and maybe that was a little bit of his downfall here. Was he perhaps felt that he didn't need to prepare his comments as much because he has been living with it for 5 years, but he's also been in the legal weeds for 5 years, and it sounds like that's what more of this opening was about. It's opening statements. There's a couple of schools of thought for a prosecutor. Is that one, you can come in and just kind of disregard the defense case and say, here are the facts, ladies and gentlemen. This is what you're going to hear. The evidence will show A, B, C, and D. And based upon A, B, C, and D, we are going to ask you to return a verdict of guilty as charged, first-degree murder, second-degree murder, whatever it is. There's another school of thought that, you know what, you do need to address some of the defense arguments and theories, if you know what they are going in. That's a big point, because you want to take some of the sting out of it, steal some of their thunder. And it seemed as though he was trying to do that a little bit here, but he got so into the weeds that it was confusing to me, and he started mixing metaphors, and it really, I feel like, lost some people. And that's unfortunate, because again, this is a case where he really could have had all 12 of these people in the palm of his hand by the end of this thing, with his as awful a case as this is. I mean, talk to me more about what it was like the last moments of this man's life. Talk to me more about how he tried to get out. Talk to me more about how he begged to be let loose. Talk to me more about how she abandoned him as he suffocated to death, and she went and took a nap. These are the things that are going to stick in their brain. These are the things, you know, part of what you're trying to do with opening statements is, one, yes, give them a roadmap, give them an understanding of what to expect out of the evidence, but two, leave them with a feeling, leave them with a lens that they're going to view the rest of this evidence coming in. All 12 of those people, if he's done his job right, should be glaring at that woman right now. They should be indignant with that woman. They should be upset for what they're about to hear and appalled that her attorney's even going to get up to give an opening statement. But this was so deficient on emotion that I think they're just kind of happy to hear him sit down at this point, which is unfortunate. So again, you know, he's a good lawyer. He's done well in the motion work, and I think he knows this case obviously very well, but he's really missed an opportunity here, which is unfortunate. So again, the mixing of metaphors, don't use analogies and metaphors if they aren't crystal clear and aren't going to, no one is going to go back into that jury room and remember the analogy about the home inspector that he gave, or this idea of the doors. And then there was some side quest we went on about vampires at one point, I think. None of it's doing well for him. Let's see if the defense can score any points here.
The opening remarks by the defense.
Judge, we invoke the rule. It has been. I've already advised the witnesses.
Okay, the rule sequestration will be invoked. Thank you. You may proceed, sir.
Appreciate y'all being here. I'll introduce you. My name is James Owens, and I represent Sarah Boone on the Prosecution decision. This is going to be several days long. Obviously, today, trying to make arrangements for the decision on I know your focus is on this case. Ladies and gentlemen, there is no microphone. No microphone. We're going to ask you. Find Sarah Boone because she was justified. Force that she used. That force was reasonable under the circumstances that existed. When Sarah Boone.
Oh, thank God.
Sarah Boone and Jorge Torres
were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine it. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other.
And that's why your case should be, this is the tragic result of alcoholism and alcohol abuse, is that horrible tragedies like this take place, and my client never intended this. Instead, you're going to hear some duct taped together, hard to understand, hard to follow narrative about how she was justified. The part that you guys may have missed in the audio is that he was saying that she was justified in her actions and reasonable in her actions. And that's where I think he's going to lose these people. So far, he's again doing fine, approaching the jury, speaking directly to them, speaking extemporaneously from the heart, good eye contact, all of that stuff. I'm just very thankful we've got better audio.
And you're going to learn with all that was domestic violence. And that Jorge Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's 2 sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, and they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day.
Thank you, Jody.
At some point, you're going to see a video from Publix, from where they live. I believe have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are these resolved? But George was very jealous of Sarah. You're going to hear the testimony about that. And that he cannot, in a certain situation, he can be very charming. But when his level of intoxication gets to a certain level,
Are you guys able to hear? I'm seeing some people say that they can't hear. Nothing's changed on our end, so I hope you can hear the audio.
moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence.
Sorry about that, guys.
Off the line. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a video close by, and Sarah thought he was going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, got her debit card, and he went over to the Publix and he got another bar. And I think that was about 5:30, something like that. And again, the Publix video showing him going in, going out, and he'll be able to see the purchase of that bottle, and he'll leave that bottle will be his orange key along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. Attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs. Their bedroom's upstairs.
You know what? I'm gonna. You could get offended by the way that he's categorizing this. They had some wine. They were down on their luck. They got a little silly. I'm actually okay with it because he's trying to be a little homespun. You got to figure the position that he's in. He's in a really tough spot, right? He's trying to defend this really, really horrific, nightmarish scenario as best that he can. And I think this kind of aw shucks presentation is probably the best way to do that. He's not trying to say this man deserved to die. He's not trying to say my client is some hero. He's saying, listen, folks, these are two people down on their luck, doing the best they can to scrape together pennies to buy the cheapest wine they can possibly find. And they drink and they act stupid and horrible things happen. That would be great. ... This was a horrible tragedy. This is not second-degree murder. But now, again, how does he perform this bank shot and say that this was somehow an act of self-defense? We'll see how he turns this one around. But so far, I'm impressed. Having seen him in court before now, didn't have the highest of expectations, but I'm impressed with how he's handling this, at least from his demeanor and presentation.
To the shower and waits for a period of time. And he doesn't come to her. at some point she gets cold, she gets tired. She wants to go see. Well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. Well, she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, "I can't post." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opening. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out. What? But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Said things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George is, the suitcase is flipped upside down. The zipper's off. 11 minutes later, Sarah has flipped it right side up. Open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay?
All right. I don't want to miss the point that he's about to make here, but I did want to jump in. So this is interesting because I was wondering, so much of the defense's cases, hands are tied by that video. You can imagine what this case would be like had they not had the video that Sarah Boone took herself. That video corners them into having to answer certain questions. And it's perhaps that video where this whole self-defense thing came from, because she says in that video, this is how you make me feel. This is for all the times you choke me, something along those lines. And perhaps it was those statements that they thought, okay, well, we have to somehow address that and turn this into a self-defense case based upon that video, because there's no getting around it. Perhaps they took a look at it, listened to it, and said, there's no getting around your malicious intent at that time that you were making that video. We can't simply say this was all fun and games and then you fell asleep. You obviously felt differently at a certain point. So they said to themselves, okay, we have to address that. Maybe that's where this whole self-defense thing came from. between you and I think the whole self-defense thing came from Sarah Boone herself, and he's doing the best that he can to spin this yarn. But he says something here that is at least an attempt to explain why she's saying the thing she's saying in that moment, and that's that she has a captive audience. You can laugh him out of the courtroom. You can say that's ridiculous. I'm not going to quarrel with you on any of that, but it is at least an explanation. And that's the position this man is in, is he has to provide some explanation for these things. They simply cannot be ignored. So his explanation, and it's not ridiculous. I mean, but it's saying, listen, yeah, he's smaller than her, but she's physically intimidated by him. And this is the first point in time when she's ever had his entire attention. And she's got a captive audience, and she's going to get some things off her chest. Again, don't come at me with pitchforks and say, that's ridiculous. I agree with you. I think we all see this case the same way, but that's an explanation. And maybe there's a juror on there, one or two, who might say, you know what, there's a point to be made that if this was an abusive home, if she was afraid of him, if this was a cycle of violence, then in these moments, she wanted to get some things off her chest. Okay, let's see this. I wanted to jump in there before he makes this next point, because I think he's about to make another important point for the defense.
That is the key to this case. Sarah Boone will take the stand.
Wow.
She will explain what happened.
I'm not surprised that she'll take the stand. I'm surprised he's saying it in opening.
She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law, every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner.
Thank you. Never stop chasing.
She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving with that. Her son comes and stays with him from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening him. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording. And it's during an argument. And he's trying to intimidate. Sarah loves you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had done a thing before. The prosecutor mentioned she wanted him to die. farthest from the truth. She loved her man. She hated the abuse. She couldn't leave him. She tried. She tried taking him out 6 or 7 times. He kept coming back. She changed the lock. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship.
I'll pause really quick to answer this question from Never Stop Chasing. But what was her BIC? I don't think that they had it for a couple of reasons. It was the next day, so it was several hours removed from when any of this took place. And I don't think they were investigating it as a some sort of alcohol-related crime. This isn't like she was stopped on the road, so they had to make sure that they had her BAC level recorded for evidence. Maybe a missed opportunity, maybe something they should have done. But at the time that she was speaking to police, after she called 911, I also don't think that there was objective signs of intoxication at that point, at least from what I see in that original badge cam kind of interview. So I don't think we have an answer to that. If I'm wrong, please somebody let me know in the comments.
Now, you're going to find that Sarah's not perfect. And, she goes, as many of us do when we drink too much, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moses downstairs looking for George. Thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees his suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex. Really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. Where her son is at. Lucas. The only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming up. Please come up. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute. Detective Rodriguez arrives. We got the body cam now, so it's recording. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible.
See, I don't know how you split this fine of a hair. Now he seems to be going back to awful tragedy. She wakes up the next day and to her horror, he's still in there, and she calls 911 and she's freaking out. How do you split that hair with this was also an act of self-defense? Again, I really feel this is don't shoot the messenger type of situation. This guy was handed a steaming pile of you know what and told to slap some lipstick on it and hope that the jurors buy it. And I know I'm mixing metaphors, but that he's having a rough time explaining how these theories work together, because it's a rough theory to make them work together, because they don't work together. And I guess you almost have to say it's admirable, given what he's trying to pull off here, that he's getting through it.
Eventually, she gives a statement to one. She gives one to Detective or Deputy Rodriguez. Well, she's not the homicide. She just responded. She's the first responder. And, they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigator. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars, and it's recorded. Right here, that. And then the next day, they take Sarah's phone. Sarah gives them the phone and signs the consent to take the phone, take it to. They have a phone extraction people at the sheriff's department where they can take in. They got all the data, all the phone calls, text messages, photographs, videos. And they finally see video. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, officer, Chelsea officer. And they end up, Deputy Cops was pregnant, or Detective Cops was pregnant. They end up, hey, we're not going to bring your phone. I'm not feeling good. Like, can you come to the sheriff's office? Which their thing was to tell you that's what I was doing. That's what they told me I was going to the sheriff's office for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videos. And so there's approximately a 2-hour interrogation that was on the 25th afternoon when she got there to get her phone. They said, well, you have to come up here and talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lied. She's not a lawyer. She doesn't know about. So.
All right. Well, that's the way they're going to explain that, is they're going to say that she's lying now during her interrogation with the police. Never a good way to start, right? Because now you're already calling your client a liar, who's, by the way, going to testify to this jury. Yeah, you've presented a reason for it. Yeah, you've said that she was intimidated and scared and they're trying to pin a murder on her, but already you've labeled your client a liar, and she's about to testify to the jury and hope that they believe everything coming out of her mouth. Again, not a spot this guy chose to be in, a spot he finds himself in. But it's not so much the opening statements, it's what he has to work with that are the problem here.
She doesn't understand he has a lawful right to defend himself. She doesn't understand that he's justified in using the force that she used. She doesn't. I wasn't there. to advise her. No lawyer was there. So she lied. And you're gonna hear that. So you're gonna have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's gonna be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about the laws, the evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're gonna have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack. But it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're gonna actually hear from some of the police officers. Maybe some body cam footage. You may see some photographs that they took of the injuries to Sarah. And some of the videos you may see her in a very happy, joyful type of perspective. Well, number one, she's intoxicated. Number two, she's safe. Recently. So her attitude is not one of distress.
Wrap it up.
We're here today, full, packed courtroom. Judge Grader's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire time. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first today on their case. They have the burden of proof. And it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush the judgment, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't opinions early on. That's hard to do, as Mr. Henderson said in open or in jury selection. That's extremely hard to do. Now you're going to hear some testimony.
Oh, come on, wrap it up.
Has been mentioned that experience. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. and find Sarah Boone not guilty. Because it's the right thing to do. Thank you.
Thank you, sir.
All right. Well, you know, first of all, can we talk about how strong the mustache is on the law clerk in the back there by the judge? Real strong showing on that mustache. You know, opening statements that I don't think anybody is going to write songs about. I think they both did a serviceable job. Both of them had high points. Both of them didn't really have low points as much as they had slow points, just parts where people I feel like got lost. You know, I mean, here's the thing about an opening statement is that you've already introduced yourself to the jurors in jury selection. Hopefully they like you. That's, in my view, 80% of the job in jury selection. Just get these people to like you, start to trust you, start to want to hear what you have to say. Now you've got an opportunity in opening statement to really give them their first take on how they should view the rest of this case. But it should not be that you're using every last minute that the judge gives you. It should not be that you're trying to touch on every single point of evidence that is going to be presented in the case. It should be the sneak preview, right? You ever watch a sneak, the coming attractions, and when you're watching the previews of a movie, it's never boring, right? You don't ever have points where you're thinking to yourself, boy, I'm learning a lot about the plot points of this movie, but I'm finding myself bored here as they slug through it. It's what is going to catch your attention and how should you feel about this evidence that you're about to see. You should know the point. You should know exactly the prosecution should get you to the point where they're going to ask you for a guilty verdict beyond a reasonable doubt. The defense should get you to the point where you say, absolutely, there's reasonable doubt here. But it should leave you with a feeling and a sense and a lens as to how you're going to view the rest of the evidence. Not that you have heard all of the evidence that's about to come. And I think that's where they both kind of fell a little bit short, is they wanted to touch on everything already. And that's maybe where they were missing the point. So I'm not going to hand out grades on this. I actually think the defense probably did a better job because they just kept it shorter than the prosecution. But both of them did an equally kind of C- job on the whole thing. Jay, hello, my friend. Thank you so much. Thank you for the congratulations. Good to see you. Thank you for joining us in the chat. Should we get to some questions? I tried to keep track of some things that you guys were asking along the way. And if you have other questions that you would like me to get to, please let me know. Let me see. Dr. Bullbutter says, love that name. Little fingers. Oh, talking about how he had, yes. She described it as his little fingers coming out of the suitcase, but that's an overt act. I don't even know if that's a question as much as a statement, and I agree with the statement. How are you going to call? And again, this is where you're seeing the problem already arise in opening statements. How is that him getting his hands out, this overt act that led to your self-defense, but you're also saying that you fell asleep, and you're also saying that it was a tragedy, and you're also saying that you're shocked that he was dead. Did you want to kill him or didn't you? Did you want to defend yourself or didn't you? Was this a horrible, horrible tragedy, or was it the final moment of you freeing yourself from this cycle of abuse? And the fact that we don't have an answer to any of that after that defense opening already shows you the problems that we have with this thing. Somebody asked a question that I wanted to get to about whether or not. Okay, here it is. Or here's one of them. Somebody was asking about this. I can't remember, but does the prosecution get to cross her after her narrative? Jody's asking this question. And I've seen a few people suggest that she's going to testify in the narrative. I don't know if that's true, and I don't know where that's coming from. And if you guys have information better than me, please let me know. But from what I've heard, they haven't asked for that. That is not something that you're given. That is something you have to ask for. If you just put your client up and say, tell us everything you have to say about this, you're going to get objections of narrative. So you have to give the court a heads up and get permission from the court to allow your client to testify that way. And it's only seen in the rare instance. We saw it in the Robert Tellis case. And I think a lot of people thought, oh, that's just kind of how these wacky defendants are going to testify from here on in. That's the first time I've ever seen it, by the way. I think I may have seen it one time in my career before then. But it's in the rare instance where the only reason why the defense attorney is not going to lead them through it is because they believe that they're about to perjure themselves, and the defense attorney doesn't want to have anything to do with that. She's already testified in a hearing here, and he led her through her direct examination on that. I think that's what we're going to see here. I could be wrong. Maybe I missed a hearing, but I don't think we're going to see a narrative. But to answer your question, Jody, yeah, of course they get to cross. Same thing as we saw on the Robert Tellis case. Pamela says, Josh, if Sarah fell asleep because she was intoxicated, would that still be considered manslaughter, even if she didn't intend to end his life? Great question. And you're already identifying a better way of defending this case. If she fell asleep already, the fact that you're already asking, can she intended enough to even create manslaughter, is to me a far better defense position. The answer is the prosecution would answer, you leave a person zipped up inside of a suitcase who's begging for their life and telling you you can't breathe. That is enough depraved indifference and gross negligence and disregard for the safety of others that can rise to the level of a manslaughter. But doesn't it seem to be a far more strong position for the defense to say, holy moly, what a horrible thing that took place. These people are alcoholics. These people are living off of their last dime. These people do not live the lives that you and I do, ladies and gentlemen. This was a tragedy, and you can maybe argue it was a tragedy that was waiting to happen, but it was certainly not a tragedy that she intended. And then go to them with that, and you probably, worst case scenario, get yourself a manslaughter. But with this defense that they're going into, of the idea that it was self-defense because self-defense requires some intent. I intended to defend myself. How? By hitting with the bat? Is that the defense? By leaving him zipped up while he's suffocating to death? Is that the defense? Is that the intention that you had? You can see already where the problems start to arise. JC Broadway says, can it be both an escape from abuse and a horrible accident? I don't know. And I think that might be the fine hair that they're trying to split with the defense, as she had a captive audience. Last thing she was going to do was let this man out. But she certainly didn't ever mean for him to end up dead. Could be that. That could be their argument. That could be the way that they're trying to go with this. To me, it seems a little difficult to follow, and perhaps difficult for jurors to hang their hat on. I don't know. I mean, again, the thing about this is, it's easy to take pot shots at a really horrible case, and the facts are really bad here for her. So she's going to have a hard time. All right. Here's another question. Super Planner Girl says, do you think Sarah declined the deal because she is a fake seeker? Why else would she have done something so dumb? I think she declined the deal. She's obviously not an unintelligent person. I mean, we've seen her speak. We've heard her written words. She's not what I would call a person who's unintelligent, but I believe she's also suffering from delusion and perhaps narcissism and perhaps this idea that of entitlement. I mean, you know, the asking for snacks and the asking for hair and makeup and the running through 8 different attorneys. This all screams of someone whose entire center of the universe is themselves. And that might be the type of person who turns down this deal because she may think she's walking. She may think, put me on the stand, let me talk to these 12 fine folks, and I will convince them of how this was self-defense. And I think that is going to come across louder than any word that comes out of her mouth. And the jurors are just going to hate this person. Let me see if I have any other questions. Just trying to run through this quickly. Let me see. Wouldn't keeping her, Alicia K. Mayo says, wouldn't keeping him in the suitcase when he's begging to be let out be the same as involuntary seclusion? I think that what the prosecution is arguing here is obviously this idea. You could call it depraved heart murder. You could call it gross indifference to the health or safety of others. But it all boils down to this same idea, Alicia, is that he's not just begging to be let out. He's begging for air. He's saying, I can't breathe. That to me is a game changer in this. He's not saying, Sarah, I'm bored of playing this game. Sarah, I'm tired. Sarah, it's hot in here. Sarah, you found me, hide and seek over. He's saying, Sarah, I can't breathe. That is a person begging for help, begging for their life. That to me is what makes this a murder case. And if you want to add on to that she prevented him from getting out by hitting him with a baseball bat, that might push this towards far more the realm of a first-degree murder than a second-degree murder even. But what the prosecution is arguing for is second-degree murder here. But excellent questions, everybody. Thank you so much for joining me. I appreciate it's a Sunday. I appreciate it's the morning for a lot of you. I appreciate that this is already a case that had its opening statements. And so the fact that you were all willing to hop on here and join me is so thrilling, and I'm tickled, and I'm honored that you had a opportunity to be here. A couple of quick things. Tomorrow, we are doing a premiere on our series that we do about 5 things. This is on the Menendez brothers. I know they're all over the news. I know there's been documentaries all about them. I know there's been this new monster series, and everybody's talking about Menendez. We felt there was actually an opportunity to give you something different on this case. And we're talking about the legal issues at play, and the legal issues that were at play in this case, as thrilling and dramatic a case as it was, when you're talking about a wealthy family and 2 brothers that kill their parents and they shotgun them to death. It's hard to say that there might be anything more intriguing than that. But actually, some of the legal issues that were at play are really fascinating when you get down to it. So we've done a premiere on that. It will be released tomorrow at 5 p.m. Pacific, 8 p.m. Eastern. Please join us in the chat. And I hope that you guys really enjoy it. It's another one that I feel like we've done some really good work on it, and we're very, very proud of it. Really did a lot of research and dug into it, and I hope that you guys enjoy it. And then the following Monday, we are going to have Gisela, and I hope I'm saying that right now, I've met this woman, by the way, so many times, and she tells me how to pronounce her name correctly, and I keep on messing it up because I'm a big old dummy. But Gisela K from Grizzly True Crime. We are starting a new series of Courtroom Confidential conversations. And so not this following Monday, but the Monday after that, we're going to air an interview that we're doing with her, but we have not done that interview yet. So if you guys have questions, if you want to know stuff about Gisela, if you want to know how she started her channel, that's really what we want to talk about. Yeah, we can talk about some true crime cases that she's following. But I want to know, I'm most interested in, how did she get into this? What is her background? Why is this fascinating to her? What motivates her? And talk to us a little bit about that. So we're going to do an interview. We've got it set up for this week. If you guys have questions, you want to know some things, please let me know, and I'll try to include as many of those as possible. But stay tuned for a premiere of that, not this Monday, but the following Monday. In the meantime, you guys are all fantastic. Thank you again for being here. I hope you enjoyed this, and I hope that you have a great rest of your Sunday. Enjoy the football. Go Dodgers. Everybody, I will see you again this coming Wednesday for another Wednesday Night Live. In the meantime, please take care and please be safe.